we have Wayfarer's expert on the docket. Let's go over it. I'm going to first make this video just a little bit about expert testimony. This is more about it being admitted at trial, but I think it's important because this document had what a lot of people might think is like a lot of fluff to it, but there's a reason for it. There's a reason his whole CV was included, and it kind of looked like navel gazing, and he really explained his reasoning here of how he got to the opinions, what he used to make those opinions, and then obviously, again, all of his qualifications. And that's because judges need to vet experts that are testifying at trial, and he's starting to lay that foundation there. I remember talking to a federal judge once, and he was talking about one of the biggest tasks for him was, preventing pseudoscience from entering the courtroom. As a conspiracy theorist myself, I was like, yeah, I get it to a degree, but then I'm like, hey, science is always changing a little bit, so. Which does make me think about, like, when DNA evidence probably first came around, and they were like, can this be trusted? I think that that's part of why OJ got off, because I think it was, like, a brand new concept then, or maybe the glove didn't fit. So let's talk about expert testimony, that's actually admitted into the courtroom here. It's really governed by Rule 702 and 703 of the Rules of Evidence. So, and part of this is because you don't have to have personal knowledge to be an expert witness, which for other witnesses, you have to have personal knowledge of the defense. So, that's why there's these extra stuff. So, a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if. Then we've got 4 factors here. The expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. B, the testimony is based on sufficient facts or data. C, the testimony is the product of reliable principles and methods. We'll go back to reliability in a minute. And D, the expert has reliably applied the principles and methods to the facts of the case. And then for expert evidence, there's kind of 3 steps. Is the evidence reliable both in its underlying principles and its application in the case? Does the evidence for the case help the trier of fact? And kind of like, is there a danger of unfair prejudice, confusion, or misleading the jury that would substantially outweigh the probative value? And so the judge is kind of the gatekeeper here, and the judge has to decide like whether the expert's approach is sufficiently reliable. And like one of the things that they can do is look at like general acceptance of the principles, but that's not necessarily the only thing. I will make another video about kind of more of the meat and potatoes about this expert's arguments that we could see from the document on the docket today.